be on the line.
This is Vice Chair Schaefer here.
Is Mr. Gaines with us?
Yes, I am.
Is Ms. Cohen back?
Yes, I'm here. Thank you, Mr. Chair.
And Ms. Stars?
I am here and ready to go.
All right, we will reconvene. We will start with item K. If Ms. Davis would just please call the next item.
The next item is A, other administrative items. The Executive Director's Report has one item, K1A, extension of time for official acts. Ms. Fleming, BOE Executive Director, will present this item. Ms. Fleming, are you ready?
Yes, ma'am. Thank you so much. Good afternoon, Chairman Vasquez and honorable members. I'm Brenda Fleming, the Executive Director. Today's report members will provide an update on the request received for extension of time for official acts. It's our standard duty that we perform. This item does not require board action or direction. It's for informational purposes only. In accordance with Revenue and Taxation Code Section 155 and State Board of Equalization Property Tax Rule 1051, the board or its executive director may grant extension of time for official acts required by rule or regulation. In the case of public calamities, the deadline may be extended by 40 days. Section 155 also requires that the executive director inform the board of any such extension at its next regular meeting. Pursuant to the provisions noted above, this memo is to inform you that the Sacramento County Assessment Appeals Board has requested and been granted a 40-day extension for public calamity. Such extension is granted for all deadlines prior to January 1, 2021. Therefore, any official acts that must have been completed prior to January 1, 2021 must now be completed 40 days after the original deadline. Each 40-day extension period is to be counted from the first day after the original 2-year deadline date. Understandably, members, we may continue to receive requests for extensions from other AABs, which will be approved, again, falling in line with the executive order, and any that we receive will be reported at the September board meeting. As of today, members, 8 extensions have been granted to the County Assessment Appeals Board. As always, members, I want to pause to thank our staff, both BOE and CDTFA partners, for their response to this crisis and their commitment to our continuity of government responsibilities while still caring for their families. And then due to our next upcoming speakers, members, that concludes my report for this month. Thank you.
Thank you. Any questions from the members? Hearing none, I will have Mrs. Davis call the next item.
The next item is K3A, Property Tax Deputy Director's Report, presented by Mr. David Young, Deputy Director of Property Tax Division. Mr. Young will present K3A operational updates. Are you ready, Mr. Young?
Yes, I am.
Go ahead.
Good afternoon, Chairman Vasquez and honorable members of the board. My name is David Young. I am the Deputy Director of the Property Tax Department. Today, I will provide an overview of Assembly Constitutional Amendment 11, also known as Proposition 19. If approved by voters on November 3rd, 2020, this measure would do 2 things. 1, it will generally limit the relief from reassessment in cases of transfers between family members, and 2, it will expand the existing property tax relief available for homeowners who wish to transfer their Prop 13 protected base year value to newly acquired homes. So if you will allow me, I will go ahead and walk through some of the major differences in what is currently available under law and what the Prop 19 proposes as an alternative if so passed. So first of all, I will start with the transfers between family members. Currently, transfers between parents and their children and grandparents to their grandchildren are not treated as reassessable events under Revenue and Taxation Code 63.1. So currently, if you were to transfer something to your child, you can transfer your primary residence with no value limitation at all. Under the new proposal, the home that you wish to transfer has to be the principal place of residence of both the transferor and the transferee. Under the old, it only has to be the principal place of residence for the transferor. The transferee can use it for anything. There is no value limit under the old, but there is under the new. And that value limit is $1 million. So as an illustration, if you were to transfer your home to your child right now, and let's say the home is worth $2,100,000, but its factored base year value is $400,000. You've owned the home for a while, and you have the benefits of Prop 13. Under the old, the child would get the old factored base year value of $400,000, but under the new, there is a limit to it. The new assessment under the proposed Proposition 19, the assessed value would be $1.1 million. So there will be an increase if for homes that have gotten a lot of appreciation. So that's number one. Number two, under the old scheme, under the current scheme, you can also transfer other real property other than your primary residence. That would count. You would be able to do it such as a vacation home or even commercial property. There is a value limit to that. That is $1 million. So if you had a second home, some commercial property, $1 million, the base year can be transferred to your child or to your grandchild and not be reassessed. Anything over the $1 million would be reassessed. Under the Prop 19, their proposal is that this is only applicable to a principal place of residence. So anything other than that would not work. Under the new, if you had a vacation home or commercial property, that would not fit under Prop 19. What will also be different is right now you have 3 years in which to claim this exclusion. Under the new proposal, you only have 1 year. So that will shorten the time. And for the BOE right now, our responsibility for this is that the BOE actually tracks this $1 million exclusion of any other types of property, a secondary home or commercial property. Under the new proposal, that since that is no longer qualifying, the BOE will not have to track it, but what we will have to do is it will have to recalculate that $1 million limit for principal residences and actually announce it. So we are responsible for making that adjustment to the $1 million. Okay. Next, I would like to cover the base year transfers from original home to a replacement home. Under current law, persons at least 55 years of age or disabled can transfer their Prop 13 base from their original home to a replacement home under Revenue Taxation Code 69.5. Also, there is one other provision for you to transfer your base year value to a replacement home, and that is for people that have had their property damaged or destroyed by disaster relief. They are also able to transfer their base year value. So first, I'll cover the base year value transfer for the people age 55 and older and the disabled. The types of property that can be transferred currently is once again principal residence. That remains the same under Prop 19. Under the current law, you have 2 years in which to complete the whole process. Either you sell your original home and buy your replacement home, or vice versa. You have basically 2 years to complete. that also remains the same. Under current law now, you have to purchase your replacement home within the same county as your original home. There are 10 exceptions to that, and those are the counties that have adopted an ordinance that allows a transfer in from another county. So there are 10 counties there that will allow you to transfer in a base year value currently into their county. The change in Prop 19, that would make it basically portable for all of California. All 58 counties would allow all 58 counties to basically take a transfer in from any other county. So you can sell your home in one county and move to anywhere in California and transfer your base year value. Under the current law, your replacement home has to be of equal or lesser value. There are a little bit of leeway there. It allows for 105 and 110% increases if the replacement home was purchased within the first year, and 110% if it's purchased in the second year. So there's a little bit of leeway. Under the proposed Prop 19, your replacement home can be of any value, so there is no value limit. There's no value limitation. The difference is that if your replacement home is actually worth more than your original home, the difference in that is added to your base year value. So they remove the base year value. You can qualify and move up to a home. The thing is, the difference between the value of your original and your higher valued replacement will be added to your old base year value. Right now, under current law, you can do it once. The only exception to that is that if you do it once for age 55 or older, you can do it one more time for disability. Under the proposed Prop 19, you have a 3-time limit. They raised the amount of times you can do it to 3. So you can do it 3 times. So that is for property transfers, the base year transfers for people age 55 and or disabled. And we have 2 more to cover, and these are base year transfers due to disaster relief. I will cover first the Intra County within the same county, and then the Inter County between counties. So right now, the current law allows you to transfer if you had property damaged or destroyed by a disaster relief. You can transfer it to another property within the same county. Right now, you can transfer for any type of property. It could be
Mr.
your...
Young?
Yes.
Hi, this is Malia Cohen. I have a question for you about going back to the last point you made about disability, a disabled person qualifying for this program. Is there a certain percentage that a person must be disabled? For example, my father's a Vietnam vet. He is a disabled veteran, and over the years, the VA hospital, they like certify the veterans if they have 90% disability, 50% disability, depending on how they were wounded during their combat service. And I'm wondering if the law specifies that the person must be at least 30% disabled or at least 60% disabled. Do you know that answer?
Yes, generally. Okay, so for this type of transfer of your base year value, there is a statutory definition of what is disabled. They do not put a percentage on it, but they require certain types of disabilities. I don't have the exact language in front of me, but I can definitely bring that back to you.
So I would imagine they would have to provide some level of documentation.
Yes, ma'am.
Okay. All right. That's good to know. You and I can take line, and I mean, I am curious to know what that level or how the legislation defines disability.
Yes, yes.
Thank you.
I will be more than happy to do that. Okay, so if it's okay, I will finish up with the Intra County and the Inter County, and I
Yes.
can open up for questions if anybody has any more. Okay, so under the Intra County, you can transfer any type of property. Under the new current proposal, it is only the principal place of residence. So you cannot do anything other than the home that you live in. Currently, the time limit in which you have to transfer your base year value is 5 years. Under the new proposal, it's only 2 years. Right now, you can do it within the county, within the same county in which your original or damaged property was in. Under the new, it expands it throughout California, all 58 counties. You can take a base year value to any one of those. Under the current, it is any value, anything over 120% of your original home's value is then added to the new base year value. Under the proposed, it's also any value, but anything over 100% is added. So those are the major differences. It changes it from any type of property only to principal place of residence. You get 5 years. Under the new, you only get 2 years. You do expand it from only the same county. Under the old, it's anywhere in California. Under the new, and in the old, it's anything over 120% is added. Under the new, anything over 100% is added. And then for the very last one is Intra County. Right now, the Intra County is principal place of residence. It's the very same for Prop 19. Under the old, it's 3 years in which to complete the transfer. Now, under the proposed, it's only 2. Under the old, for Intra County, there are only 13 counties that will let you import in from a different county. Once again, under the new, it's anywhere in California, all 58 counties. And those are the major differences between what is currently available for transfers between family members and transfers of base year value because of age, disability, or disaster relief. I am available for any questions you may have. This concludes my presentation.
Thank you. Members, I have several questions, and I'm sure others do too. Can we hold those off until tomorrow? Because I understand we have several speakers waiting for item M.
Okay.
Yes, Mr. Chair, I'm happy to my questions till tomorrow.
Are we good?
No, I'll say tomorrow, but Mr. Young, thank you for your presentation. I want to appreciate
Of course,
that.
I will be available tomorrow.
Thank you for your patience, members. Mrs. Davis, if you can call the next item.
Yes, sir. The next item is M1A, Public Policy Hearings, an update on the impact of COVID-19 on property tax administration. This item will be presented by Chairman Vasquez. Mr. Chairman?
Yes. Members, with the impact of COVID-19 closing access to county buildings and hearing rooms, we took steps to extend the AAB's 2-year deadline, both directly and through the governor. The current extended deadline expires on January the 31st of 2021. Since the closure may continue for some time after that, the purpose of this hearing is to receive input and recommendations on how AABs can conduct hearings remotely and at the same time ensure due process and protect the rights of all parties. We have scheduled several speakers to address 3 separate items listed as A, B, and C on your agenda. Due to the multiple excessive heat warnings and the likelihood of rotating power outages throughout the state, together with the governor's directives to reduce energy demand and close state offices at 3 p.m. through tomorrow, August 19th, we will address only item A today and will continue with item B and C during tomorrow's meeting. To stay within the time available, I will ask everyone to accept the board members to reserve your questions and comments until all speakers on each items are finished. After that, we'll allow time for public questions and comments. Thank you. With that, we currently have 3 speakers from the Judicial Council, and the courts will ready to go, who will present. The first to explain policies and practices being put in place for the courts to conduct remote hearings and ensure due process. If we can start with the first one, is Mr. Robert, and I hope I'm not butchering your name. Is it Young, Chief Operating Officer of Judicial Council of California, available?
Yes, I'm here. Thank you very much.
Welcome. You may proceed with your presentation.
Thank you. Good afternoon. So my name is Robert O. Young. I'm the Chief Operating Officer for the Judicial Council of California. I'm joined today with the Honorable Sheila Hansen, who is a judge at the Superior Court of California in the County of Orange. She is also the chair of our Judicial Council Information Technology Advisory Committee. Also with us is Mr. Greg Harding. He is the Information Technology Director for the Superior Court of California, County of Placer. Before we begin our discussion and our overview, I'd like to take just a short amount of time to provide you with a little overview of the judicial branch and provide you with some context for the topics that we'll be discussing today. So the California Judicial Branch consists of approximately 2,000 judicial officers across 500 courthouses throughout the counties of California. We process just over 6 million cases per year. About 3.8 million of those are criminal infractions. The remainder of those are spread through varying criminal cases and other civil cases, including family and juvenile cases. In general, over the past few years, we've seen a decline in filings. However, certain case types have actually been growing. In particular, mental health filings are up about 10 to 20% year over year. The judicial branch is structured with a focus on local court decision-making to address the unique needs of the local population. But we do have common platforms, shared best practices, and branch-wide standards and policies to ensure that we are efficient and effective in our delivery of services. So over the past few months through the pandemic, the courts have been able to continue to offer these services, some in limited or reduced levels as appropriate, but we've been able to, through technology, be able to continue to offer these services and provide access to justice. One of the things that we did was institute 2 emergency rules, and those provided the ability to have remote appearances, which include video, audio, and telephonic appearances in criminal and civil proceedings, with criminal proceedings being done with the consent of the defendant. So today what we're going to be doing is providing an overview of what we've been doing with remote hearings, some of the challenges, and the lessons learned. We'll talk about remote hearings, video streaming, a little bit about remote interpreting, and then managing digital evidence. So with that, I'll ask Judge Hansen to talk about remote hearings and video streaming.
Thank you, Mr. O. Young, and I would like to thank you, Chairman Vasquez and honorable members. As you must recognize, the COVID-19 pandemic required my court and all of our courts throughout the state to drastically change the manner in which we operated. Prior to the pandemic, we gathered together in courtrooms and courthouses throughout our state. And once the pandemic hit, obviously in an effort to protect the health and safety of the parties, litigants, witnesses, and all of our court employees and the public who entered our buildings, we had to reimagine how we provided access to justice, and we had to do it in a very quick time frame. So we focused on developing a mechanism and a strategy to limit the number of persons who actually were physically present inside of our courthouses and our courtrooms, so that we could provide and comply with the CDC guidelines and the requirement of social distancing. So to do that, we implemented video remote technology to allow courts to handle the cases that we handle on a daily basis but without requiring the actual parties, attorneys or witnesses or public to be physically present inside of our courtroom. We recognized that we had two different sets of population that would need to access our courts remotely. The first were those individuals at a fixed location, such as a county jail or a state prison or a state mental hospital. Their freedom was limited and their access was limited. So in order to deploy a video remote solution for those populations, we worked very closely with those justice partners, and we deployed a commercially available video conference solution that was agreeable to those locations and also useful for the court. The remaining population included not only attorneys, but self-represented litigants, witnesses, and everybody else who enters into our courthouses. All of those individuals we had to recognize had a different level of experience and capability with technology and different levels of resources. So we needed to deploy a solution that gave all of them access reliably, and it was very important to us to ensure due process that no one was either advantaged or disadvantaged by use of a video remote technology. Fortunately, today our population is increasingly familiar with remote video technology. Many of them have either attended presentations or training. Perhaps they've obtained services such as medical appointments, or they've socially interacted by way of video. So we began by examining a variety of commercially available products and services that provided remote video connectivity. And because the technology ecosystem really conforms to one standard, similar to telephone standardization, we found that we did not have to develop complex technical guidelines, but rather we could adopt these commercially available solutions. And they would allow nearly everyone. Of course, there's some limitation on age of a particular individual's device or a particular operating system, but for the most part, the vast majority of individuals, if they did have a smartphone or a computer or a tablet, they could connect by use of these video remote technologies. We also, in some of our courts, provided a publicly accessible monitor that they could access if they did not have any such device. And then we focused on making sure that those individuals who would be appearing by way of remote could actually be heard and seen in the courtroom. So it required us to evaluate what equipment we had in our courtrooms. Some courtrooms already had evidence presentation equipment. We had to assess whether or not this technology could integrate with that. And in many cases, we had to buy new equipment. First and foremost, cameras, so they could see what was happening in the courtroom. We assessed the need for cameras, audio equipment, monitors, and we then deployed that throughout our court in Orange County. And the vast majority, if not all of our courts throughout our state today, are able to handle virtually all of their case types by allowing individuals to appear remotely. And this is everything from handling a traffic ticket, where you can now appear remotely without having to travel any distance, to the courtroom, to family law matters, probate, all of our case types, including criminal. Our appellate courts have been able to likewise deploy video remote technology to allow the attorneys who would normally be physically present in the courtroom arguing their cases to do so by way of video remote as well. Once we were able to deploy that solution, we also had to address the fact that the public has always had access to our courtrooms. They are public proceedings. And in order to do that, what we did in Orange County to ensure that the public still had the opportunity to see what was happening in each and every one of our courtrooms, we live streamed, or made the decision to live stream each of our proceedings. So on our public website, you could go to the public website, you could click on live streaming, you could pick out what individual courtroom you want to observe, and when you click on the public link, it actually takes you from our web page to our YouTube channel, and you can watch and hear what's happening in the proceedings. courts throughout the state have also implemented opening up the courtroom for limited seating so the public could be present, or opening up audio streaming so that they could hear the proceedings. In doing this, we recognized that there were challenges. First, one of the largest challenges, I think that was probably the most unexpected, was the need to provide technology support. Unexpected in the standpoint only that that's not something a court has ever had to do before. So now suddenly, while you have individuals who can access the court remotely, if they're having a particular difficulty connecting, they are calling and they're asking for tech support. So that is something we are learning to do that we had never done before. We have also, some of the challenges were adding additional staff necessary to actually monitor the proceedings from those individuals who are connected, making sure they're connected, letting them know when their case is going to be called, either muting or unmuting them. Again, not terribly complicated, but additional work that we weren't used to doing before. Some of the lessons we learned was not to overcomplicate the rules and the procedures by which we began doing this. We found that we didn't have to publish or impose strict technical guidelines, but that it was necessary to publish the supported browsers and hardwares from the particular solution that we were using. We in Orange County are also using a variety of different commercially available solutions. We didn't select one particular device or solution. We are using a variety of them. We recognize that all of the platforms are maturing at a very high rate, and it's allowing us to learn from each of those and evaluate them as we go forward. Another lesson learned was ensuring that we provide a mechanism so that users can actually test their browser before their first hearing, and we can do that by just opening up the line or the connection perhaps for a certain period of time before their actual hearing or case is being called, and allow them to do that. And while I say we don't impose strict technical guidelines, of course, as a court, we do focus on the security standard of the particular platform or the service that we're using. And we have made a decision to make sure in our court that it does have security protocols in place. We've adopted those that typically have end-to-end encryption and meet federal certifications of security. Additional challenges are how do the parties introduce evidence, and I think Mr. Harding will speak about that in a moment. But we have been able to successfully use this technology to ensure that we are continuing to serve the public, that the public has access to our courts, and that we are ensuring that justice is served and that the cases that the public has within our courts are continuing to be processed. So that is a brief overview. Of course, at any time, I'm happy to take any questions if there are any.
Great, thanks, Judge Hanson. And so we'll continue with our topics and then take questions at the end. I did want to add on one comment based on what Judge Hanson was speaking of, related to some of the protocols that we've implemented at the local courts. Across the branch, we've actually published a what we're calling the Pandemic Continuity of Operations Resource Guide, which provides some best practices, some suggestions in terms of social distancing, managing jury trials, facilities, and HR suggestions to make sure that we are maintaining the health and safety of both the employees as well as public and members who are coming into our courthouses. And so part of the overall plan that we have in dealing with this pandemic is documented in this continuity of operations resource guide. The other thing that I wanted to comment on just very quickly, as you heard from Judge Hanson, throughout the state, we are holding remote hearings However, language interpretation is actually a very important factor for many of these hearings. There are over 200 languages that are spoken in California, and of the 39 million people who live in California, about 7 million of them have limited English proficiency. And so interpretation is a big service that is needed within the courts. And as you can imagine, with many of the hearings now being remote and video, we need to have a way to provide those types of services. And so I just wanted to share with you the fact that we did conduct pilots with video remote interpreting. So again, to ensure the safety of the interpreters as well as people coming into the courts. You can have a party as well as the interpreter be remote, and using special video and audio equipment provide for that video interpreting service. And so I just wanted to mention that that's another component that we have as part of our remote hearings. With that, I'd like to introduce Mr. Greg Harding, again, the IT director from County of Placer, who's going to, Superior Court of California, County of Placer, who's going to talk about digital evidence.
Thank you, Rob. Thank you for letting us join your conference today and to share some information about the Placer Superior Court remote appearance and remote evidence system. The system was made possible by an innovation grant provided to the Judicial branch. The remote evidence system was created to resemble the in-court experience and to ensure that the remote party has equal access to justice. The system is just one of many ways that courts throughout California are allowing the presentation of evidence. Other courts are doing it in a different manner than the Placer Superior Court is, but the way that we have it is the Placer County Superior Court system allows the party the ability to upload their evidence ahead of their court hearing. The uploadability is turned off 1 hour before the hearing, and the folders are placed into view mode. In the view mode, all parties can see all folders. This is how the Placer County Superior Court is handling the disclosure of evidence between parties. Our system is currently only used in small claims cases, where typically the parties would share evidence right before the hearing by passing the physical documents to each other. Once in view mode, no other documents can be uploaded or deleted. During the court proceedings, the parties inform the courtroom clerk what documents they want to be marked and entered into evidence for the court. Our system is based on Microsoft SharePoint with a custom front-end interface created by a third-party vendor. The interface ties into our court management system and allows us to have the parties schedule and upload the evidence with little or no court participation. Our biggest challenge to the system is getting both parties to sign up and upload their evidence, and supporting when only one person is on remote and one person is physically located at the court. The court has scanning stations set up for the person who physically comes into the courthouse to allow them to upload their evidence so the remote party can see it. This is probably our biggest obstacle, as typically when people show up to the courthouse, they may or may not have the technical experience to upload their documents. So far, this system, we have been able to hold our hearings, and we have approximately about a 55 to 60% success rate where both parties appear and the evidence is uploaded and their case is able to continue. At this time, without this type of system, the court would not be able to hear these small claims cases due to the COVID-19 pandemic. Thank you.
Great. And so with that, that concludes the presentation, but if there is time, we're happy to address any questions that anyone may have.
Thank you. Members, given the time, I'm wondering if we should just continue with the rest of the speakers, then we'll ask questions of all of them after.
Sounds good, Mr. Taylor.
Are you good? Okay, so let me go ahead and call up the next set of speakers. And this is under the Office of Administrative Law and other administrative hearing agencies. And we have 3 speakers for that. If we have, I believe the first one is Mark Krueger. Is he available?
AT&T operator, can you check to see if Mark Krueger is available?
Certainly. Mr. Krueger, if you're on the lines, please press 1, then 0 at this time, and I can open up your line.
I am available. I'm sorry I had you on mute.
Welcome, Mark. I understand you're the presiding administrative law judge for the State Personnel Board.
Right.
Okay.
I am. So good afternoon, Chairman Vasquez and members of the board. I am Mark Krueger, and I am the presiding administrative law judge at the California State Personnel Board. Just to give you a little context of what we do, the State Personnel Board is constitutionally created by the state constitution, and its duties are to uphold the merit principle in state civil service. In part of that process, the State Personnel Board reviews disciplinary actions taken against state employees, among other things. If an employee appeals their discipline to the State Personnel Board, generally, they are entitled to an evidentiary hearing before an administrative law judge where witnesses are called, examined, cross-examined, and other documentary evidence is introduced into evidence as well. So when COVID-19 came around and the state offices were closed in mid-March of this year, our hearings basically came to a standstill, as most all of them were in-person hearings that took place in various offices throughout the state. When it became apparent that there was not going to be a quick resolution to the current crisis, we, as a group, the Chief Administrative Law Judge and several of our senior administrative law judges, looked for commercially available video conferencing tools in order to attempt remote hearings of our evidentiary hearings. Ultimately, in June, at the end of June, we were able to create a series of orders regarding exhibits and witnesses and identified a commercially acceptable platform where we could hold evidentiary hearings remotely. The biggest challenges of drafting those orders was, number one, not being too specific and allow enough room in the orders to allow amendments or do what we needed to do to take care of the practical issues we may face that cannot be anticipated when we initially crafted the orders. And as other speakers have mentioned, I believe Judge Henson mentioned, one of the primary difficulties was how we would handle evidence. Some of the evidence in our cases can be voluminous, and we had determined that the best way to handle that was to require the parties to share not only hard copies of their evidence at least 10 days prior to the hearing, but also share that with the SPB along with an electronic copy. Witnesses were also a challenge as well. In our situation, many of the witnesses are from the appellant's workplace. So in order to designate a place where witnesses would testify, we asked that the department set up a witness room close to the employee's place of employment where witnesses can come and testify one at a time, while the parties and the representatives appear remotely from some other location and examine the witnesses in that manner. Ultimately, we were able to distribute these orders in the end of June and began holding our video conference evidentiary hearings beginning at the end of July. Our initial startup time was August, but actually some parties requested that they be allowed to participate in a video conference hearing, although they were not scheduled at the time to do so. We granted that, and that hearing went off successfully, including not only the witnesses appearing at the witness location, but also the distribution of the evidence and its inclusion in the record. The biggest challenge has been technology for the parties, both the employees and the agencies that we serve. There several times we have had parties indicate that they do not have the equipment necessary to participate in a Webex proceeding, and some of the cases, if they can show me that that is a legitimate reason, have to be continued to allow sufficient time for them to acquire the necessary hardware. Those are basically the challenges that we've been facing. So far, our system in terms of distributing the evidence has worked. I'm hoping that ultimately, once we become more familiar with the process and these video conferencing sites become more mature, and that we would be able to just move straight into electronic evidence rather than having to share copies. That would certainly save the parties a significant amount of time, and obviously the State Personnel Board a significant amount of paperwork. But the upsides for us were that it eliminated a significant amount of travel. The administrative law judges would have to travel throughout the state to hold in-person hearings, which is essentially eliminated by the remote hearings. We can conduct more hearings than we could if we were in person because of not only physical space limitations, but also travel issues as well. But the technological issues remain, and that is lack of equipment. Sometimes parties do not have internet, and when we are dealing with employees that are representing themselves, sometimes compliance with the orders that we have distributed can be challenging. But we try to work with all the parties to make sure that they have a full and fair opportunity to put on their evidence, have a full and fair opportunity to observe and participate in the proceedings to satisfy our due process requirements. That's the end of my presentation. I'd be more than happy to answer any questions you may have.
Thank you, Mr. Krueger. We will have some, but we're going to go through all our speakers. If I can call up the next one, and I believe it's Miss Jill, and it looks like Sklichman. I hope I'm pronouncing that right. Presiding Administrative Law Judge, Office of Administrative Hearings and General Jurisdiction Division. Is she available?
Yes, I'm here. Thank you. So
Welcome.
yes, I'm, well, thank you, Chairman Vasquez and other members of the board for inviting me. I am the presiding administrative law judge in the Oakland Office of Administrative Hearings. We do have two divisions, special education appeals and general jurisdiction, which includes licensing discipline, some employee discipline, teacher layoffs, disability hearings, and a whole variety. We preside over hearings for over 1,500 different state and local agencies. And the duration of our hearings ranges from a couple of hours to several weeks or longer. Similar to the State Personnel Board, we have an administrative law judge who presides over an evidentiary hearing. They've always been in person until March. We also regularly conduct settlement conferences and mediations. And our participants in our hearings include deputy attorneys general, county counsel, private attorneys, and we also have many self-represented litigants. Some parties need interpreters, others are hearing impaired, some have access to the equipment to participate in a video conference, others do not. Many of our hearings are reported by a certified court reporter, and others are recorded electronically. Some of our hearings are open to the public and others are not. So we had to adapt and learn through experience since the shelter-in-place orders were imposed. Our experience has been challenging but successful. After some delay and trial and error, we now preside over remote hearings at the same rate as we presided over in-person hearings a year ago. So once the stay-at-home orders were imposed, we began issuing orders converting our hearings to telephonic hearings. Thankfully, the Office of Administrative Hearings had been looking in the future toward having some remote hearings, so all of our administrative law judges already had laptops with cameras and microphones, which was a big help. So they could go home and they could perform their jobs from home. So after we started with telephone hearings, we then moved to video conference hearings. And I think it's important when considering a video conferencing platform to determine which features are important for your agency. Some platforms offer a separate channel for interpreters so that those needing translation can speak to one another while at the same time listening to the hearing, allowing for simultaneous interpretation. Some platforms provide a user-friendly way to move participants in settlement conferences into separate caucus meetings, and others offer artificial intelligence software that provides closed captioning, which may be able to aid those with hearing impairments. The number of potential participants may also make one platform more suitable for one agency over a different platform. We have found video conferencing to be preferable when available to telephonic conferences. Video conferencing may be helpful when the hearing judge is assessing witness credibility or wants to confirm whether the witness is being coached or reading from notes. It is easier for a court reporter to do his or her job if they're able to see the person who is speaking. And in some cases, we have done some in-person hearings, but we've actually found remote hearings to be preferable during the pandemic because participants in an in-person hearing have to wear a mask, they sit apart, they may be concerned about their safety, and so actually assessing credibility can be more difficult when a witness is wearing a mask and feeling unsafe. But in order to participate in a video conference, the participant needs to have access to a computer or a cell phone that's equipped with a camera and a microphone, and that they need to have sufficient internet speed. So we have had a number of participants that have used their cell phones, and that has worked out just fine. But the main issue that we've run into with self-represented litigants is that they may have, their home internet doesn't have much bandwidth, and so that can cause some technological glitches. And also, some people are just afraid of technology and they resist it, and so some participants just appear by telephone. That's, makes them feel more comfortable. And so we allow either way. You can appear by phone or by video. And if possible, I offer a practice session with parties, especially in longer hearings, so that they can try out the software before their hearing starts. And I know our ALJs always go over a lot of issues that can come up during a video conference hearing before they go on the record, and they will do things like exchange telephone numbers so that and make sure that the participants have the call-in number and code handy right in front of them in case their call is dropped or their video is dropped. Another thing we've learned is that you should be mindful of the background that is being shown on the screen. Our software allows you to blur the background or to put in a virtual background so that you can keep your home environment private if you're working from home. You also need to be aware of how backlighting can affect how you appear on the screen. And I'd say that, a lot of our hearings, we do have technical glitches that come up, but I think what's really important is for the hearing officer to let people know that these things happen. It's okay, we'll sort it out. We may have to have you hang up and call back. Patience is important, and I think we just try to really reassure the participants that, we're all in this together and we'll get through it. Some platforms can be set to announce when a participant enters or leaves a meeting with the sound of a chime, and that can be helpful if you have 6 or 7 people in a meeting and they're all important participants and one gets dropped off and you don't notice. So if you have that chime, that helps. We also go over rules of etiquette and remind parties that they should behave in the same way that they would in the hearing room. And we also encourage people to let the judge know if they're having difficulty. If they can't hear something or can't see something, then to speak up. And if the hearing is public and there are observers, we will provide the link to join the meeting to any observers. The judge allows them to listen, but their microphone should be muted so as not to interrupt the hearing. And we also encourage participants to mute their microphones when they're not speaking because rustling of papers can interfere with the ability to hear and to create a clear record. We also created procedures for the introduction of documentary evidence. In the past, the parties would just bring their exhibits to the hearing room. Initially, we had the parties upload their proposed exhibits to a secure file transfer portal that we use for filing motions and pleadings, but the judges don't have immediate access to those documents that are uploaded that way, and the parties don't have any access to those documents. So we have piloted a third-party evidence platform that allows parties to upload documents in real time, and for everyone who has been invited to register to view all of the evidence after it's uploaded. Parties can upload documentary evidence as well as video and audio evidence, which can be played during the hearing. This kind of evidence platform has allowed our hearings to proceed more smoothly, and the hearing officer can mark and admit the documents in real time during the hearing. We encourage participants to exchange their documents electronically in advance of the hearing, and we set deadlines in the orders for uploading proposed exhibits. Any agency using a third-party platform for uploading evidence will need to consider how evidence will be accessed in the event that the evidence platform becomes unavailable during the hearing. Our administrative law judges often download exhibits from the platform onto their desktop before the hearing so that they're available in the event of an issue with the evidence platform. So with appropriate software preparation and patience, our remote hearings have been successful. We feel we are providing due process to the parties. And in fact, some parties and judges have expressed that they prefer remote hearings, which have the benefit of less travel time, less expense, and the comfort of appearing from your own home or office. And that concludes my remarks.
Thank you. Now we'll move on to our third speaker, Mr. Mark, and it looks like Ibele, Director, Office of Tax Appeals, is our third speaker. Is he available?
Yes, Mark Ibel here.
Ibel, I'm sorry.
That's quite all right. I've heard all sorts of versions. So I'm the Director of the Office of Tax Appeals, and just as an overview of the office, we hear all appeals from actions taken by the Franchise Tax Board and the California Department of Tax and Fee Administration. We hear appeals that are from taxpayers that are represented, also those that may not be represented. About 80% of our appeals come from actions taken by the FTB, and about 20% are based on actions taken by the Department of Tax and Fee Administration. Those would be business taxes and excise taxes and sales and use taxes. So about 85 to 90% of our appeals are decided based on the written record. They're decided by a panel of 3 ALJs, and an oral hearing is not requested. So about 10 to 15% of the cases are request an oral hearing. And prior to March of this year, we had about 20 to 25 oral hearings a week in our offices in Fresno, Los Angeles, and Sacramento. Our last oral hearing was in February in Los Angeles, and in March, we began at the request or at the discretion of the taxpayer, we began holding audio conferences, audio hearings, telephonic hearings. So the taxpayer could choose, yes, I'd like to go ahead with the hearing telephonically, or alternatively, I'd like to delay. We had a lot of taxpayers that were banking on an oral hearing and be able to present their evidence in person. So we've had a lot of postponements. So we had the telephonic hearings March, April, May, and in the midst of that, we were continuing to look at different ways of enhancing the oral hearing process by using video conferencing. So we looked at a number of different platforms, including those that we've all used in the past 6 months, Zoom and Teams and Skype, and we've settled on Webex, and we've been using that increasingly successfully since June, and that is based on sort of the ability of taxpayers to be able to use it. It seems to work for the tax agencies. They had some security concerns, and so we've had 21 video hearings using the Webex platform. And I should add that these continue to be at the discretion of the taxpayer. So the taxpayer now can decide, I'd like to have a telephonic hearing, I'd like to have a video conferencing hearing, or alternatively, I'd like to continue to postpone. We've had about, as I indicated, we've had about 21 or 20 video hearings using the Webex system. We're having some, even as we speak, we have hearings now in Sacramento today, Wednesday, and Thursday. The process that we use at OTA is a fairly extensive briefing process where evidence is exchanged between taxpayers and tax agencies. So all the evidence is scanned, it's digitized, it's available to both parties well in advance of the hearing. And there is also a pre-hearing conference that takes place before the oral hearing is actually held. And at the pre-hearing conference, again, this is before the panel of 3 ALJs with both parties represented, and the evidence has gone over the questions about what are the issues in the matter and are gone over. And as part of that process, we have used Webex in addition to telephonic means to hold these pre-hearing conferences. So if a taxpayer decides to go ahead with a video hearing, there's, I guess you could call it a little bit of a practice session using the pre-hearing conference. In addition, on the hearing date, the taxpayer meets with representatives of OTA and our IT team to go over the system, make sure they're familiar with in particular, the mute button, with how the system works, how they should present their material, and make sure that they're comfortable with the technology. I should add that one of the things that Webex is able to do is that we can take witness testimony, people can upload their documents and share them with other people on the Webex hearing. Everybody should have copies of the evidence that's presented, but they would have it might be something that the taxpayer or the tax agency wants to go through, wants people to look at it and have a bigger visual presence for it. We've also had a hearing where the taxpayer representative provided additional documentation in the form of a PowerPoint, which was then shared with the ALJs and the other party. So we found it to be a fairly flexible system. There's always glitches and issues. One of the things that we want to make sure that we do, that the judges, in advance of the hearing, of the pre-hearing conference, at the 15 minutes or 20 minutes before the hearing starts and before they go on the record, to make sure that you say who you are before you start speaking, because sometimes it's a little unclear who's talking. And, you know, this gets into the weeds a little bit, but everybody's is labeled on screen. So under each of the ALJs, it says ALJ Smith, ALJ Jones. And similarly with the tax agencies, they're clearly labeled who are the people from the tax agency, who is the taxpayer, who is the taxpayer representative. We do have some issues with familiarity with the equipment, and some taxpayers who perhaps would like to participate but don't because of a unfamiliarity with technology or a little bit of a fear of it. We are in the process of setting up a dedicated room at OTA whereby taxpayers would be able to show up at our facility and be able to use the equipment there and be assisted by IT people if they wanted to go in that direction. Again, you know, we're not a court. We're very taxpayer friendly, lenient with respect to evidence that's produced. If for some reason evidence is not available to both parties prior to the hearing, for example, sometimes a document becomes available that wasn't available before, the judges generally admit evidence except if it's irrelevant to the case. So generally that would be admitted. It's up to the discretion of the ALJs, but generally would be admitted, and then to make sure that both parties can have an adequate look at that evidence, the record would be held open after the hearing concludes for everybody to look at that evidence then. We have a court reporter for every hearing, and these are also recorded, and they're all live streamed as well. So I think in terms of difficulties, I think again it's the technology hurdle that I think a lot of people have to get over and to get familiar with it. I think the protocols in terms of I think the previous speaker mentioned protocols in terms of words, language, behavior, that we want to keep it at the same level as if it were a in-person oral hearing, and we try to set the standards for that with our ALJs. I think that's all I had with respect to an overview, and happy to answer any questions.
Thank you. We will at the end. Thank you for your presentation. We're going to move into the county boards and the AABs, and we have one speaker for that topic, and that is the speaker actually representing that will be Mr. John McKibben, committee chair, California Association of Clerks and Election Officials, will speak on behalf of the county boards of equalization and AABs. Is Mr. John McKibben available?
Yes, I am, Mr. Chairman. Can you hear me all right?
Yes, welcome. Go ahead.
Thank you. Thank you very much, Mr. Chair. Members, I am John McKibben, representing CACEO, the California Association of Clerks and Election Officials. And I have the pleasure today of giving you a very broad overview of what is happening in counties with regard to business continuity plan developments and the extent to which county boards of equalization and assessment appeals boards are using remote hearings to address appeal workload during the COVID-19 pandemic. Also give you some at least in very broad terms, how your board may help clerks and assessment appeals boards. In preparation for today's hearing, we conducted a very brief telephone survey of a cross-section of counties to gather available information on the subject and some statistical data as well. CACEO invited 30 counties to participate in the survey, and 20 of them responded. Of the 28 counties responding, 10 are not holding hearings of any kind at this point. But among the 18 responding counties that have held hearings or are continuing to hold hearings during the pandemic, 6 of those are only holding in-person hearings while complying with social distancing and other requirements. 1 of these, however, will begin doing remote hearings in September. 3 of those counties have held both in-person and remote hearings, and 9 are holding only remote hearings using telephone, video, or a combination of each type of equipment. Platforms that have been experimented with so far include Microsoft Teams, Zoom, Webex, and BlueJeans. Among the 12 responding counties that are holding remote hearings, 6 have held only administrative and procedural hearings. The other 6 have at least some evidentiary hearings as well as administrative hearings. Of the 6 responding counties that are holding remote evidentiary hearings, nearly all have very little experience with them so far, with San Diego County being the primary exception. However, the great majority of responding counties either already have planned for remote hearings or are in the planning process right now. Most of those, however, are large counties as opposed to the smaller folks. Most responding counties report that they hope to do both evidentiary and administrative remote hearings once their plans are in place. At least a handful of those counties are waiting for the BOE or other statewide authority to issue guidelines and protocols for remote hearings, most especially guidelines and protocols for evidentiary hearings. They're very interested in hearing what the folks, the preceding speakers had to say about that. However, to date, fewer than half of the responding small rural counties have done any planning in this regard. Although most counties have not yet had a lot of experience with regard to remote hearings, it seems that many taxpayers either prefer or at least agree to participating remotely. Positive responses from taxpayers to the invitation of a virtual hearing range from a low of 33% and go up to as high as 95 to 100% in some of the responding counties. However, at the same time, it's also clear that a significant number of taxpayers would prefer to have in-person hearings. And this is true also of both of not only taxpayers, but Assessment Appeals Board members. Many of the taxpayers are willing to sign a waiver of the 2-year deadline in order to have a later in-person hearing when they feel it is safe to do so. Some counties require a written statement or waiver form in which the taxpayers have affirmatively waived his or her right to an in-person hearing. This is done to provide protection for counties against later litigation. 15 of the responding counties still have open cases that were either postponed or continued due solely to COVID-19, and all but one of these is either a large or mid-sized county. We note that in the smallest responding counties, the BOE or Assessment Appeals Board meetings are held infrequently, ranging anywhere from monthly to yearly or as needed. However, in most of the large and urban counties, they meet daily or at least weekly. Obviously, this is driven by radically different workload around the state. So what are the general conclusions that we can draw from this quick telephone survey? First, we found that there is a widespread interest in remote hearings for public employee safety and in order to be able to continue working steadily through county appeal caseload during the pandemic. And this is true in nearly all of the responding large counties and at least half of the mid-sized counties, but only in a relatively few small rural counties where the need appears to be less. There's also very widespread concern that procedures and protocols for remote hearings be developed for general statewide application that will prevent continuances of hearings that we can't afford, and for future litigation that might ultimately invalidate county board decisions. Clerks generally understand and are very concerned that virtual hearings, especially remote evidentiary hearings, will be significantly more burdensome for clerks than existing procedures. Much of the experience so far illustrates that more staff will be needed to not only receive and store, protect, and distribute evidence, but the hearings will often require at least 2 clerks to perform the usual clerking functions at the hearing and to also control and support remote participation of the 2 parties to the proceedings, the board legal counsel, and the board members themselves. Taxpayers seem to be divided with regard to their willingness to have a remote hearing. Although there appears to be considerable interest in virtual hearings, it's also clear that there's considerable reluctance to do so on the part of many taxpayers. And as I said, similar feelings expressed by Assessment Appeals Board members. Generally, counties that conduct remote hearings in which the taxpayer intends to participate do so only with the oral or written consent of the taxpayer. Those who do not agree are often required to sign a waiver of the 2-year deadline. The counties using remote hearings have developed guidelines and protocols with their individual legal counsels, but many recognize that standard statewide guidelines and protocols would be valuable. Guidelines and protocols for virtual hearings are particularly important with regard to evidentiary hearings. Clearly, development of these protocols and guidelines will be the most challenging in every respect and will require great care in their development. Guidelines and protocols must somehow take into account differing local conditions in terms of the local impact of the pandemic, volume and complexity of appeals, and especially county resources. And I believe some of these considerations are mentioned in Judicial Council's recent guidelines for reopening the courts. A primary obstacle to the successful use of remote hearings is the fact that counties will be implementing these new procedures at a time of severe county revenue shortages. Again, CACEO members, thank you for this opportunity to weigh in on this important matter. Tomorrow we will have clerks and counsels from several counties of different sizes and experiences to testify about planning for and or implementing of remote hearings in their respective counties and to answer your detailed questions about the challenges and solutions that they've developed. By the way, I would like to thank Malia Cohen and her staff for persuading even more counties to testify tomorrow than we were able to recruit. Her efforts are much appreciated. Thank you very much, Mr. Chair, members.
Thank you. I appreciate that on behalf of my staff. Thank you.
Thank you. Just members, I just want to remind you, we got a short window here. We're going to try to squeeze this in. So we're going to move on to the next one, which is the assessors. And we have 2 speakers representing the assessors. I believe it's Mr. Chuck Leonhardt standing in for Mr. Gayko.
I'm here. Can you hear me?
Yes, go ahead.
Okay, good afternoon, Honorable Chair and board members. I'd like to make the following remarks on behalf of President Gayko, who was called away this afternoon. I am John Gayko, Stanislaus County Assessor and President of the California Assessors Association. I want to thank the board for having this public discussion of the needs of county clerks of the board, local assessment appeals boards, the assessor staffs, taxpayers, and their agents who appear before them. California is a diverse state with 58 counties that experience this issue in very different ways depending upon size and location, and their needed solutions vary. Small counties generally have fewer assessment appeals and therefore very few that result in actual hearings. These counties are along the North Coast, far north, and along the Sierra Nevada mountains, and many, if not all, are proceeding with in-person hearings using face coverings and social distancing. Mid-counties are primarily throughout the Central Valley, Central Coast, and North Bay areas. Assessors in these counties generally report manageable appeal workloads, but report a mixture of strategies that their AABs are using. Some are using in-person hearings with social distancing. Others are using visual meetings for processing of administrative matters such as stipulations and withdrawals. Assessors are making plans to proceed with virtual hearings if adopted by their clerks and AABs. Stanislaus County, as an example, is moving forward with in-person hearings using face coverings and social distancing. Urban counties are primarily in Southern California and the Bay Area. These counties are generally impacted by a large number of appeals with significant carryover appeals, which are nearing the 2-year statute of limitations to be heard. These counties are most likely in need of proceeding with virtual hearing capacity to resolve their workloads. The San Diego County Assessor has participated in a number of virtual hearings and reports that the process has worked well overall, but reports that some minor technical issues with document sharing. Los Angeles County is working towards holding virtual hearings, and the assessor is prepared for and looks forward to participating in virtual hearings. The Alameda County Assessor reports that their AABs are going to return to in-person hearings after attempting some virtual hearings. Challenges. Assessors' view on viability of virtual hearings vary. Some do not support the use of virtual hearings. Most assessors are generally concerned that the virtual hearing process must make document display and sharing as efficient as possible to allow all participants to be able to make their presentations and arguments clearly and be fully heard by the AAB. Many assessors generally anticipate that appeals for commercial and industrial properties or professional representatives should be able to participate effectively in this environment if adopted by clerks and the AABs. However, assessors express more concern about the ability of many homeowners, especially older homeowners, having the necessary technology available or comfort level with the technology to fully make their case. We thank you for this discussion and look forward to learning more today and tomorrow. Thank you.
Thank you. Next, we have Mr. Larry Stone from Santa Clara County Assessors. I believe he's on the line.
Yes, thank you, Chair Vasquez and members of the board. I'm Larry Stone, and I'm here in my capacity as the assessor of Santa Clara County. But before I comment on remote hearings, I would like to express my appreciation to the board and staff for their efforts in the recent executive order from the governor. Unfortunately, the executive order is so limited that it will be of little help in Santa Clara County. As a result, our Assessment Appeals Board has decided that to avoid running the 2-year statute, they must proceed with in-person hearings, which began, coincidentally, just this morning. Unfortunately, remote hearings are not a silver bullet. However, I recognize that these are not normal times, and this pandemic may rage for another year or more. Doing nothing is also not an option. We cannot allow appeals to backlog endlessly. So my suggestion is that we wade into this and not jump into the deep end of remote commercial appeals hearings. Appeals boards should consider remote hearings for appeals that typically do not involve attorneys or expert witnesses, such as value hearing officers or residential hearing officers. These types of hearings are usually short and do not have an overwhelming amount of documentation. The documentation they do have can usually be exchanged in advance. Not ideal, of course, but may be a necessary thing in a pandemic. In addition, there are a number of procedural components to a hearing that can be done remotely, such as pre-hearing conferences, stipulations, and of course withdrawals. I would strongly recommend, however, against remote hearings for major commercial and business appeals at this time. The issue is concern for due process and transparency. One dispute with Levi Stadium, for example, consumed 21 full-day hearings. Thousands of documents were exchanged in real time, and numerous experts were cross-examined. I believe remote hearings for major taxpayers would be an invitation for due process lawsuits that could ultimately impact all remote appeals. AABs could not be assured that participants testifying on either side were not being coached off a camera or referring to documents and materials that were not part of the evidence. Cross-examinations and rebuttals could be hindered or compromised. So finally, remote hearings could provide logistical challenges as well for clerks, county assessors, county councils, assessors, and taxpayers. So for these reasons, I think AABs should consider remote hearings very cautiously. Focus on the routine residential appeals and learn from those experiences first before proceeding with remote appeals and hearings. Thank you.
Thank you. Now we'll move on to the taxpayers, and we have one speaker for that, and that is Mr. Chris O'Neill, the chair of the California Alliance of Taxpayers Advocates. Is he available?
Yes, this is Chris O'Neill. Can you hear me?
Yes, welcome.
Thank you, Chair Vasquez. Thank you for convening these sessions on these very important topics. As one of the leaders of a taxpayer advocate group, we do find this is a very important topic, and that it's an area that we think the State Board can provide a lot of guidance in, both to assessment appeals boards and as well to assessors and taxpayers. And my comments today are going to be limited just to what the experience of taxpayers has been recently. Tomorrow, my colleagues, Mr. Waldman and Mr. Kochadoff, will speak to the various issues we think the State Board of Equalization needs to address in providing guidance to AABs in establishing standards for remote hearings. But let me just speak to experiences of taxpayer advocates. I canvassed our membership, CADA's membership, to find out what the experience has been with remote hearings over the past 6 weeks or so. And as you have heard, there haven't been very many remote hearings, and particularly for complex cases. In fact, it wasn't but last month, July, when a number of boards just started scheduling even in-person hearings. A couple of our members have had experiences with remote hearings. One of those was in Ventura County, and the experience suffered from some difficulties. One was that there are just practical problems with the type of software and system that is in use in Ventura County. The taxpayer advocate was unable to see the faces of the Assessment Appeals Board members or the assessor while providing testimony. And I think that probably has to do with the camera placement and the type of software system that was in use. Another problem is that in remote hearings, there's a tendency to want to march right through from beginning to end. And oftentimes in-person hearings, there's exchanges of information. Parties are allowed a few minutes to review information they haven't seen before, and then they proceed into testimony, cross-examination, rebuttal, whatever the case is. That's difficult to provide in remote hearings where there's really a desire to keep the cameras rolling, if you will. The other experience we had, one of our members was involved in the remote hearings that have been going on in San Diego County. And again, there were some practical problems due to the way the systems are set up. One was that, again, it was not possible to see the Assessment Appeals Board members on screen and how they were receiving the information. And as you know, Assessment Appeals Boards, they are the trial court in an equalization proceeding, in a local equalization proceeding, and that's because there is no appeal to Superior Court under a de novo review on factual issues. So it's very important to be able to present the factual issues, all of the facts, fully and completely to an Assessment Appeals Board. And I think that Assessor Stone just referred to that. I think Assessor Linhart also made reference to that, and Mr. McKibben of the Clerks CA CEO also did. This is going to be the biggest issue, we think, and that is handling of the evidence, handling of the documentation, and allowing adequate views of witnesses, of board members, of participants in these proceedings. The other problem that the taxpayer advocate in the San Diego proceeding faced was there's no ability to present rebuttal evidence. And just to back up a little bit, rebuttal evidence is information that you provide in response to the other side's case. It's not information that's typically exchanged beforehand because you don't know what the other side's case is going to look like until you're in the hearing. Obviously, when you're attending a hearing remotely and someone raises an issue and perhaps you want to pull a statute out and show it to the board, or maybe a property tax rule, or maybe a case, or maybe there's a document that's specifically on point. Well, you can't do that, at least not quickly. And this, the handling of rebuttal testimony is going to be a major concern, I think, for everyone, including assessors. And just so the board knows, Property Tax Rule 313E specifically says that all parties in an assessment appeals proceeding are entitled to present rebuttal evidence. So this is something that's going to have to be handled. Just quickly to update, there have been in-person hearings, and some CADA members have attended those hearings. Typically, they require all of the social distancing, they require masks and so forth, and the inconveniences of that obviously are a concern. Very hard sometimes to hear people speaking through a mask, and the distancing sometimes makes it so that people are completely on different sides of the room, even in large, chambers of the boards of supervisors that are sometimes used. So I think those are our comments. Those are the comments from CADA on what's currently happening. We do look forward tomorrow to presenting more about the continuity plans that we believe the assessment appeals boards are working on right now, and also discussing what we think are going to be topics for which the State Board of Equalization is going to have to provide guidance, possibly even some rules or regulations, or maybe guidance in the form of LTAs or other types of, maybe there will be additions to the Assessment Appeals Manual. And those will be discussed. We will have at length, one of our representatives, Mr. Kotchadoff, has a number of topics that he's planning to raise with the board during the hearing tomorrow. So I thank you for the time to present. I hope this has been helpful in our experience as taxpayer advocates. And again, we sincerely appreciate the board allowing taxpayers to speak during these proceedings.
No, thank you. And thank you to all the speakers. I think you've all shared some real good insights and information for the members to consider. But before I forget, let me see if there's any public comment out there. Ms. Davis?
Yes, Mr. Chairman, we do have 2 written comments that we've received, which will be read by Mr. Nanjo. Mr. Nanjo, are you available?
Yes, I am. And have a correction. We have 2 rollover comments on M1 from last month, which we will read first, and then 2 additional comments on M1. The first rollover comment from July will be read by Ms. Lisa Renati, and it will be that of Ms. Kwiatkowski.
This comment is from Rosemary Kwiatkowski. I, Rosemary Kwiatkowski, Deputy County Counsel, represent the Alameda County Assessment Appeals Board, AAB. Due to the COVID-19 pandemic, the AAB requests that an executive order be issued granting a tolling, an extension of time, regarding the 2-year statutory period within which to hear the assessment appeals due to the COVID-19 pandemic. The assessor and the AAB have worked diligently to resolve the cases. However, the AAB still has many cases that will need to be heard before the end of the year in order to meet the statutory deadlines. I would like to elaborate further during the public comment period. Thank you. That concludes the comment from Rosemary Kwiatkowski.
And if we can have the AT&T operator reach out to Ms. Kwiatkowski, I believe she wanted to also make an in-person comment.
And ma'am, if you're on the line, please press 1 then 0. We'll open up your line. And I've had no one queue up, sir.
Okay, that's fine. We will continue. The next public comment is from Annette Ramirez, and she states as follows. Chairman Vasquez and members of the board, thank you for this opportunity to comment and for your letter to the governor dated June 11th, 2020, requesting an executive order extending and tolling the deadlines within which County Assessment Appeals Board must make a final determination on property tax appeals. Although San Luis Obispo County Assessment Appeals Board requested and was granted by your executive director extensions of upcoming deadlines under Revenue and Taxation Code Section 1604(c), close paren, such relief is limited in both time, paren 40 days, close paren, and scope, paren number of deadlines covered, close paren. Consequently, we are concerned that it will be inadequate due to the stay-at-home orders, limits to the number of hearings on each meeting date, to ensure social distancing and resultant backlogs, and a potential increase in the number of decline in value appeals because of the pandemic. Since the state proclamation of emergency was issued and given Ms. Fleming's action, our board has not heard any appeals. However, our board will need to begin conducting socially distanced in-person hearings next month due to approaching deadlines. Based on all of the above and with authorization provided by our board and support from the San Luis Obispo County Assessor, we respectfully request that your board continue to advocate for an executive order, either in the form set forth in your June letter or in an alternate format. Example, an executive order extending deadlines to a time certain. Our board also plans to submit a letter of support for such an order to the governor. If there's any additional information that we can provide in support of your request, please let us know. Thank you. Annette Ramirez, Deputy Clerk to the Assessment Appeals Board, and Erica Stutke, Deputy County Counsel to the Assessment Appeals Board. Then Ms. Renati has two additional public comments to read. Ms. Renati?
Yes. The first one is from Michelle Pine. It states, Assessment Appeal Board hearings are an important function for the community. Other counties have successfully implemented teleconferencing for the AAB hearings to best protect the health and safety of the public and the staff involved in the hearings. It is important for Santa Clara County to implement teleconferencing as a viable, safer option to allow the community to exercise the right of appeal. And the next comment comes for item M1A, comes from Nedra Millwood. She states, I worked in the Santa Clara County Assessor's Office, and it is very important to allow AEB hearings to happen via teleconference to ensure the high-risk workers in the public, their health and safety during the COVID-19 virus environment. And that concludes the two comments.
Thank you, Ms. Renati. Also, just for the record, Chairman Vasquez and Vice Chair Schaefer and board members, Ms. Catherine Kramer, we read her public comment in relation to K1A earlier. She also asked that that same comment be utilized for M1C. I know that's on the schedule for tomorrow, but just for the record, we will go ahead and attach that to the records, but not repeat the exact same comment. Thank you. And that's all I have right now for M1A.
Thank you. Ms. Davis, do we have anybody in the queue?
AT&T operator, can you please check to see if there's anyone who'd like to make a public comment who was not called?
I'd be glad to. Ladies and gentlemen, if you'd like to provide a public comment, you may press 1 then 0 at this time. And once again, if you'd like to provide a public comment, you may press 1 then 0 at this time. And I show no one wanting to provide a public comment at this time.
Thank you.
Thank you. Members, do we have any closing comments before we wrap this up?
Mr. Chair, can you hear me?
Yes, go ahead, Ms. Member Cohen.
Okay, just want to let for the record, I've gotten off the computer screen and I'm now just calling in. I do have a couple of things that I wanted to say, and I have some questions to ask the presenters. Will there be opportunity tomorrow to hear from them, or are we shutting down in the next couple minutes?
Well, we're shutting down in the next couple minutes. I'm hoping we could reconnect with these folks in the morning because I have some questions myself as well.
So how do we get confirmation as to whether or not that can happen, that we connect in the morning?
Let me ask.
I don't know if you have anything.
Let me ask Brenda, do we know that if we're going to be able to reach these folks in the morning or sometime tomorrow?
I'm told, Mr. Chair, that they're not available. So let me just get my questions on the record.
Go ahead.
For things, Chief Henry Nancho, I would recommend that to the speakers today we ask the questions because a lot of them may not be available tomorrow. Thank you.
Go ahead, Member Cohen.
All right. Well, thank you, everyone. Thank you, Chair. Thank you, everyone, very much for your presentations today. I appreciate the perspective. The information that you provided was and is actually incredibly valuable. A few questions that I'd like to ask the presenters and certainly get on the record. You may feel free to respond and emailing, copying all of us on the email. But first, acknowledging your own experiences and lessons learned to date related to remote hearings and what you heard are the concerns raised by the AAB and the assessors. I'm curious to know, what do you believe are the three most important issues that the Board of Equalization and the Assessment Appeal Board should be focusing on first? How do we prioritize a list of concerns? I'd like to know what we should be focusing on first. And then additionally, my question would be, what would you consider as your greatest challenge in ensuring that due process rights are protected in your remote hearings? And I'd appreciate if you could describe the steps that you've taken to address these challenges. I'd like to ask also if each organization representing a tier of facts here today, so we've got Judicial Council, we had the SPB, OTA, and others. I'm curious to know if you had, or if you have any statutory authority to host remote hearings prior to the pandemic. I may have missed your prior response, so I apologize in advance if you provided this information in your presentation. But if not, what authority are you convening your hearings? So those are my questions on the record. Thank you for giving me an opportunity, and thank you for your contribution, Mr. Chair.
Not a problem. Is there anybody on the line, especially from the judicial speakers, that's able to address those questions?
This is Judge Hanson. I can address first with respect to what statutory authority prior to the pandemic did we have authorizing remote appearances. We did not have specific authorization for video remote, but we did have specific authorization for telephonic. So we, coupled with the chief's emergency orders, we used that to allow us to proceed. There was some video remote authority with some criminal defense case, particularly arraignments, which are their first appearances, that authorized us to go forward. But we were able to proceed in most circumstances by agreement of the parties on the criminal side, even if not specifically authorized, and then by analogy to the telephonic that as to the authority. In terms of the greatest challenges in ensuring due process rights are protected, I think number one would be to make sure that there are procedures so that neither or no party receives either an advantage or disadvantages by appearing remotely. So to make sure they had adequate and equal time to present their information, to exchange their evidence. Again, evidence exchange is somewhat problematic in that we have to have a digital procedure by which to do it, or electronic. And it can be as simple as emailing to all parties and sharing the information, or a custom application like Placer developed where the parties could have a portal and actually submit it to the information to the court. So having procedures that they're both treated fairly, making sure that there is the adequate ability to view the parties that are appearing remotely. So you have to make sure that your equipment in terms of monitoring that shows the visible presentation both shows the party who is appearing remotely and gives them access to hearing and seeing the proceedings, as well as ensuring the audio quality is adequate so you can hear. Those are some of the things that we have addressed to make sure the due process rights are protected. Knowing that the court is responsible, as a judge, I'm responsible for the proceeding. I do have the ability to monitor the proceeding as it is ongoing to ensure that those due process rights are protected, and that's what has given us the comfort and the confidence to go forward.
Judge, I just had a quick follow-up to that. Given the fact that you're running these, especially the evidential hearings, have you been challenged or sued on those in terms of due process?
the not sued, the challenge will come by way of appealing what we're doing in the local trial courts. So far, there hasn't, quite honestly, been time to litigate that issue. There is an ongoing, there are certain ongoing civil cases in which there are jury trials in progress, while there has been some attempt to have immediate writs or appellate review granted. It has not been conclusively determined yet. So we don't have an appellate court opinion or obviously a Supreme Court opinion that has upheld the process or the procedures. It's just been too new.
No, I understand. Thank you. And then, yeah, I'm assuming you were listening to the speakers, specifically the assessor from Santa Clara, Mr. Stone. I believe he was talking about when you're dealing with a huge, like a big multi-corporation, hearing where you have so many documents and legal briefs that it could be a little bit of a challenge. Have you experienced that yet?
I don't have personal experience with very extensive litigation. Typically in litigation that is as complicated as that, you are dealing with attorneys that have greater experience typically. Whether or not the taxpayer has that same experience, if they're represented by counsel, I assume they do. I have found they're usually in often a better position to make sure that they can make adequate use of all of the technology. One advantage I have found by using video remote technology is the participants who are testifying by way of video remote technology are allowed not to comply with the CDC guidelines, so they don't have to wear a mask. And in courts throughout our state and county, there are various different application of the masking requirements. Some courts have allowed a witness to remove a mask. I'm not aware of any court that has mandated a witness remove a mask, and some courts don't allow a witness to remove a mask. So if you are judging the credibility of someone who is testifying, video remote does give you an opportunity to definitively analyze their credibility by way of viewing them not masked. Now, a lot of it will depend on what you can see on the monitor. If you're also trying to assess the credibility of individuals while they are not testifying, can you view them at the same time the witness is testifying? So those are all issues to consider.
Chairman Vasquez, this is Larry Stone from Santa Clara County. I found this hearing very, very informative. It seems like the judicial side of this issue is much more advanced than the assessor side of the issue at this point, at least. One of the biggest challenges that assessors have is we have such a broad range, 58 counties all over the state, populations in the multi-millions like LA down to, I don't know, Alpine County has 750 registered voters or something like that. And so the biggest cost would be the biggest problem, and it has a lot to do with cost, is the technology. So the implementation among assessors, I suspect, would be very, very different, even if we were as sophisticated as I see some of the judicial folks are. And even if we could afford the cost for that kind of technology, which some counties could. I'd look forward to this if it could be done, without a due process challenge. But so I think you'll see, a wide variety of responses from assessors, simply given by the fact that, the number of appeals they have. Some small counties don't have that many appeals. But the technological costs would be close to the same, I would think. Thank you.
Thank you.
This is Chuck Lenhart. I would echo what Larry said.
Thank you. Any other questions from any of the members?
This is Vice Chair Schaefer.
Yes, go ahead, Vice Chair.
I was intrigued to hear one of the objections to the remote hearings being that they were having some trouble hearing speakers because they were wearing a mask. I understand our legislators take off the mask when they speak, which makes a lot of sense. I know when I go to see my dentist, I can't understand what she's saying because she's got a mask on. And you notice that we don't wear our mask because we're speaking and we are socially distanced, and we also work as a family with each other. I would like to see that our appeals boards in all 58 counties allow masks to be removed when people are speaking. And it should be uniformity, because sometimes they throw political accusations. If you're going to wear a mask, you must be a Democrat. If you're not going to wear a mask, you're going with the president. That's nonsense. I think that it would be in the public interest if we would just know that it's a matter of policy that anybody testifying in an appeals board, we don't have authority over the courts, but we do over our appeals board, that they be permitted to testify without the mask because it enables better hearing. And that's very important, that you don't have a muffled expression from one side of a case and a clear expression from another side of the case. That's just my opinion, and I think it speaks to common sense, which is really what we're all about, fair and equitable treatment. That's part of it is having uniformity and the best presentation possible under the very difficult circumstances we're living under. Thank you.
Thank you. Any other comments from the members?
Yeah, if I could, Member Gaines.
Yes, go ahead, Member Gaines.
Yeah, I just want to thank you for bringing this forward and seeing how we can advance things at the assessment appeal boards. And I thought it was interesting, Mr. McKibben's comments in reference to some of the rural counties. And I'm just trying to get a better sense in terms of, what are they doing for their assessment appeal board meetings? If they're not embracing technology, is it because there's just not that many cases? But I want to make sure that taxpayers are getting their due process, as a result of the challenges we have with COVID. So I don't know if Mr. McKibben is available or not, but he did that survey, and he could clarify how it's being handled in the rural counties. That would be helpful.
Mr. Chairman, this is John McKibben. I'd be happy to try, and Chuck Leonard might want to jump in as well. Of the counties the small rural counties that responded, let's see, there were 8 responding small counties. 4 of those were not currently holding hearings at all. The other 4 were doing hearings, mostly in person, 1 via video, 1 was using a combination of in-person and telephonic hearings. It appeared that the counties that are not conducting any hearings at all have no real need. That's something of a guess on my part, but these are counties where the appeal rate is quite small, and clearly these counties have not had any problem, at least so far, with an expiration of the 2-year deadline. So okay. I think taxpayers will be served, but they're not under pressure right now to hold hearings during more dangerous times, perhaps. And maybe this is a period of time where they wouldn't be holding any hearings anyway.
Okay. Very well. Yeah, that's helpful.
The appeal rate being so low.
Yeah, thank you very much.
Mr. Chair, this is Malia. I just wanted to acknowledge Mr. Schaefer. I just wanted to acknowledge Mr. Schaefer's comments and just let him know that we will be upholding all public health directives, all directives at all times. So there is no sacrificing of those directives. So if a mask is required, a mask is required. Social distance is required, of course we will do so. I wanted just to put out there to the presenters,
If anyone had any other questions or comments or answers to the questions that I put out, I heard one response. I didn't know if there were any other responses to the 3 questions that I posed about 10 minutes ago.
So this is Jill Schlickman from the Office of Administrative Hearings, and I will tell you that we had an executive order from the governor that suspended the right to object to a remote hearing pursuant to the statute that usually governs the hearings that we conduct. And so we have relied on that since that executive order came down. The due process challenges, and we have hearings, that last for weeks with thousands of pages of documents, but I think the online evidence platform, which automatically paginates everything, has really helped that. The biggest challenge, I really feel the biggest challenge is people's fear of participating remotely. And once they get started and once the ALJ, reassures them, or we have a practice session, then everybody can calm down, and really the hearing proceeds very similarly to when we were in person. I don't know if that helps.
Absolutely, it does help. Thank you.
Mr. Chairman, this is John McKibben again. If I could just respond to Member Cohen's question. If it's all right, I would like to defer trying to answer the questions that Ms. Cohen raised, all good ones, by the way, to tomorrow's testimony, when we will have clerks who have actually been involved on site with planning and working on putting together remote hearings, as well as legal Assessment Appeals Board legal counsels who can answer the legal questions. I don't feel very well positioned to try to answer those, if that's all right with the members.
Absolutely, it's all right with me. Thank you, Mr. McKibben. Who's that, Mr. McKibben or John Gagel? I'm not sure.
John McKibben.
That was John McKibben.
Thank you, yes.
Members, I'm going to have to go ahead and wrap this thing up. We will reconvene tomorrow. Like I said earlier, we just were able to address A. We will take up items B and C tomorrow. So we're not officially adjourning, but rather just recessing until tomorrow at 10. And hopefully we can start right on time at 10, because it looks like we have a pretty packed agenda as well for tomorrow. And we're going to be under the same time restraints as we were today. But thank you all, especially the speakers, the members, staff, for your patience and all your hard work. With that, we will go ahead and not adjourn, but recess until tomorrow at 10 a.m. Ms. Davis, is that it?
Yes, sir.
Thank you all.
Thank you, members.